an extremely long time, you think, then probably what we are going to need to do is discuss having another dedicated hearing date for the proceeding that you're here for. I also have a couple of people that have been trying to get in the waiting room since I started, and I don't know what the issue is, but I'll try to do the cases that don't involve them, and then we'll see how that works out. Go back to them as we get there. The last thing I will say is that we are, if there's anybody, I know how these things are working in this day and age, and there are a lot of people that are maybe trying to juggle 2 different courts at one time and that kind of thing. So if you are one of those people, let me know. If you have a federal judge somewhere that's going to get madder at you than I am, let me know, and we'll try to work out what we can and get you out of here so you don't get in any trouble with the big guys. That being said, if nobody has that, then we're going to call just in the order in which these cases are popping up on my docket. The first one I have, nobody is here for, I believe, because it's been settled, 18 CI 718. I just wanted to call that to let anybody go if they are. That is Sweeney et al. Versus Diversicare. That's the one that they have settled it, but they have not tendered an agreed order, so it's still on the docket technically. But the second case I have, and I don't know if we have everybody here for this one, but we'll try, is the estate of Johnson et al. Versus the estate of Gray et al. That one got rescheduled? Oh, okay. Never mind. Apparently that's been renoticed. The third case I have is Jackson et al. Versus Dillard, DBA Dillard Farms and others.
Yeah, good morning, Your Honor.
Good morning, Your Honor. Joe Mattingly for Farm Credit.
Hello, Joe.
Good morning. Your Honor, this is Farm Credit's motion for summary judgment and an order of distribution. And I know that Mr. Zielke filed a response late yesterday evening. And I know with the court's time restraints this morning, I guess my suggestion would be if the court would provide a short period of time for us to reply to the response that was filed, and either at Mr. Zielke's preference, reschedule it for argument or let it stand submitted at that point.
Your Honor, this is Larry Zielke, and good morning. And Mr. Manley is correct. I would concur with him that we can't do it today. He is entitled to a reply, which he can take as much 10 days, whatever he wants. And then I would prefer to have a dedicated date, Your Honor, that we can argue this, because it's somewhat complicated. I got math going on and issues going on and changes in affidavits. So I've got a lot on my plate.
Yeah, there's a lot going on here. I've read the motion. The deputy clerk brought me your response this morning, Mr. Zielke, so I've read that. I didn't know, Davenport, I see you down there. I didn't know if you had a plan on filing anything or sticking your toe into these waters.
That's unlikely, Your Honor.
Okay, all right. So it seems like maybe the only thing that I would anticipate being filed would be a reply by, I don't want to call you the wrong thing, Farm Credit, right?
Correct.
Is that close enough?
Close enough.
Yeah. And again, it would be fair to give you whatever time you think you might need. What I think might be the best thing to do, but you all tell me if you disagree, would be to let you file your reply. Let me take a look at it, and then I can get my staff attorney to get with you all, and we'll come up with a mutually convenient day to get back together. I mean, these remote hearings are wonderful for that kind of thing. It makes it a lot easier to schedule. We don't have to get it all planned out ahead of time as much as we used to when you guys were having to drive 2 or 3 hours, you know.
That's right.
Sure.
So can you all live with that?
Good plan,
That's
Joe.
fine, Your Honor.
All right. I will, Mr. Mattingly, what do you want in a reply time?
A couple of weeks would be fine, Judge, if we could have maybe 14 days.
All right. Can you live with that, Mr. Zielke?
Sure can, Judge.
All right. So we'll allow 14 days for a reply after I get that reply. And what you might want to do, the one fault that I have with our e-filing is that I don't get notice when a pleading gets filed. So if you would email me or something just to let me know that that's
Will
been
do.
filed, especially if it's sooner than 14 days so that I can go ahead and take a look at it. And then, like I said, we'll get on the horn with you guys or do a email chain or whatever it takes and get all you guys together. Okay.
All right. Thank you, Your Honor.
And Chris, Mr. Davenport, are you going to want to be in on the hearing too, if we have one?
I will, Your Honor. And I would just ask after I look at Mr. Zilke's response in depth, if I choose to respond to either of these, either the motion or response, if I may do that within the 14 days as well.
Yeah, that'll
I
work.
think that's unlikely, but I haven't looked at Larry's response with any type of
Sure.
real
Sure.
effort yet.
And Mr. Thornton, I didn't mean to be leaving you out. I forgot to ask you if you wanted to file anything.
That's okay. If I need to, I'll speak up. I'm in the same boat as Chris.
All right, good deal. Well, I'll give you that same 14 days if you decide that you want to squeeze something in there. Okay.
I can't imagine I will.
Okay. Well, that'll work too. All right.
All right. Thank you, Your Honor.
Either way is fine with me. All right. So that takes care of us on that case, unless you all have anything else you want to bring up.
No,
No, Your Honor.
No, Your Honor.
Thank
Thank
you.
Thank you much.
Thank you.
Sanderson versus Graves et al.
Judge Kelly Lester for the plaintiff, Billy Sanderson.
Kenwood Pruitt, Judge. I'm here for David Jones this afternoon or this morning.
All right. All right, sir. How are you?
I'm well, thank you.
We've got competing, I guess, for lack of a better way to put it, competing two motions, a motion for partial summary judgment by our plaintiff and a motion to set for trial by our defendants. Is that right?
I think I filed both motions, Judge, and I actually
Oh,
think
did you
that
file that? I'm
I
sorry.
did. That's okay. And the motion for partial summary judgment, I think, has been bumped to the March hearing date to allow them to file a response to that.
Oh, okay. That hadn't gotten into my file yet. If you all
I think that's right. Is that what your file reflects, Mr. Pruitt, as well?
Well, I was a little bit surprised to hear about the motion for partial summary judgment,
Okay.
so I'm happy with that.
All right. All right. Yeah,
Well,
that just, I don't know what's happened, but I don't have that yet. So, but that's fine. I'm far be it from me to get in the way of your all's agreement if you have one to move that.
No, and I don't think I filed it in time for it to get on. I think they hadn't had 10 days to respond yet. So we just need to get a trial date if you'll give us one. I don't know how you're doing there.
Yeah. Yeah. Most of you, if you've been on any of these, I have a little bit of reluctance just because of the uncertainty of where we're going to be at any given time. The good news, I guess, from my standpoint, and from your standpoint, is that we're so backed up as far as trials go that I wouldn't be able to give you a trial date in the next 9 months or something like that anyway. So surely, and I'm in famous last words, but surely a year from now we'll be able to do things that we can't do now. So long story short, I can give you a trial date, but it's not going to be real soon unless you want me to stack it on top of some other trials that we've got. Because, when you go a year without trying anything, and of course, our criminal docket, we have way more trials than civil. So I've got a huge backlog of criminal trials that I've been kind of bumping 6 months or so at a time. And we're on about the third bump on some of those. So you tell me, I guess, Miss Lester, you're asking, do you want it on top of some other cases and just hope that it works out? Or do you want it by itself? Or do you want it some kind of hybrid? Some of the things that I've been doing are, giving us 2 trial dates, a first, and then if that doesn't work, a second, and then maybe that works. I don't know if you all are interested in that, but.
Yeah. I think I think this case is going to end up being tried. And so I think we should shoot for a date in and of itself. I'm scared to put it on top of something else and then it just gets bumped even farther.
Yeah, that is a possibility, of course. All right. Give me just a minute here to grab my calendar. Let me
Judge?
All right. It looks like to me that if I'm going to give you a day that I don't already have a trial on it, it's going to have to be probably roughly March of next year.
Okay.
That's fine with us, Judge.
And depending on
just-
how many days you need, that's going to get hairy too, because, you know, you've been involved with trying to set things before, and, you know, some weeks I only have 3 days to play with and that kind of thing. So I wouldn't think this would take more than 3 days, would it?
No, I think it should only take 2 days because I
Yeah.
don't think facility should be at issue, but if it is, we need 3 days. So, but no more than 3 days, I would be shocked. You'd be ready to kick it out by the Thursday. I think.
Yeah. I could do, the week of starting on, Tuesday, March 15th. And we could do, 15, you know, any of those 3 days in there, whether it's 15, 16, 17, or 16, 17, 18, however you would want to do that. It's fine with me. Just tell
Okay.
me. And,
Let's do the 15th, 16th, 17th.
okay.
That's fine here, Judge.
All right, good deal. Let me pencil that in here. And then let's put a pre-trial maybe around the first part of February, just because it's so far out. And looks like the available Mondays in February, the earliest Monday in February would be the 7th. So let's put it on for February 7th. And you've seen these orders, but Mr. Pruitt probably hadn't. I don't know that he's had a case we've set for trial here. So, you know, I'll have an order in there setting those dates. There will be some expert disclosure deadlines and some kind of real broad proof deadlines. And, you know, I encourage people, if they want to do something more specific than that, to do it. But this would be enough of a framework that you all would be able to get everything taken care of well in advance of the pretrial. Okay?
Sounds good. Thank you, Judge.
All right. When is our other hearing going to be?
I think it's set for March.
22nd? Okay, 22nd. Tell me. All right.
So, and Mr. Pruitt, I will email you a copy of that motion if you have not seen it yet. I think we did file it about a week or so ago. So,
I'm sure David's aware of it, so, but I'll make sure he knows about it.
okay. Thank
All
you
right.
all.
I
Thank
shall
you,
see you
Judge.
then. Thank you.
All right.
I'm sorry? No. Unless it's filed out of order. Hazel Enterprises LLC versus Whitlow et al.
Good morning, Your Honor. Chris Wiley on behalf of the defendant, Ditech Financial. This is my motion for leave to file an amended answer to assert a cross claim in foreclosure.
Okay. Is there anybody that is taking umbrage at that? Doesn't look like there is.
I haven't heard any objection, Your Honor.
I didn't expect that there would be, but I didn't want to just sign the order and because it had been noticed. So there could have been somebody raise an issue. There just wasn't. That looks like it's been electronically filed, if memory serves. So I'll be able to get on when I finish here and get that order entered. Okay.
That sounds good. Thank you, Your Honor.
All right. Thank you.
Have a good day. Bye-bye.
You too. Bunch versus Creek et al. See, who do I have on that?
Judge, me, Ron Hampton,
All right.
Miss Smith, maybe. I'm not sure who's there
Yeah.
for them.
I think I have Miss McCall. She's on mute right now. I'm going to have to, yeah.
Oh, hi.
There we go.
Madeline McCall for Carl and Andrea Creek, Your Honor.
All right. Very good.
Judge, this was my motion to set for trial. We've taken just a little bit of discovery. We took my client's deposition. We had the defendant set the same day. And I think I had court, his ran long, so I had court and we continued theirs. Theirs is somewhat difficult to get rescheduled. Mr. Creek stays out of the country. Miss Creek's around. I could take her, but and I think I saw their objection to my motion to set it for trial. I do owe them some information based on Mr. Bunch's deposition, but just as you stated a while ago, I've been in front of you for a couple times and I need to get this case back on the track. You know, it's been sitting on the side for just a little bit. Knowing the trial dates are so far off, that's why I filed the motion, because I knew it'd be pretty far off, and that way we at least would get us back moving in the right direction. So
Yeah, if it certainly, as you just heard, if I set this as the first trial set on any given day, you know, we're going to be talking about March or later of next year. So, I mean, you know, 13 months from now, which ought to be enough time for everybody to get their discovery. Now, that being said, I don't have a problem with not setting a trial right now and maybe setting it for a, you know, some sort of pre-trial or status conference in a few months to see how the discovery is going and to, you know, step in if anybody needs me to make anything happen. But, you know, I guess, Mr. Hampton, I'll let you tell me which one of those you would prefer. And then Ms. McCall, having heard everybody's positions there, can respond if she wants to.
Well, Judge, knowing that this so far away, I don't care to set it for a date, because if we wait 2 or 3 months, you know, I do owe them some information, and I gotta, I guess, get more aggressive about making sure the defendants appear for their depositions. I don't know what Mr. Creek's current location is, but if we wait 2 or 3 months just to see if we've got that done, then we're going to be that much further down the road. That's why I filed this motion, just kind of get back on my radar and you know, get it, as I said, get it moving forward. So
Understood.
I don't know what position the defendant takes on that, since it's so far off. I knew they probably didn't realize how far it would be before you set the date anyway, when they filed their objection.
All right. Ms. McCall?
Yes, Your Honor. We probably don't want to set the trial date yet. We think it's best to just set a date for discovery completion to try to get those documents, and then a pre-trial conference thereafter.
Well, let's look at it like this. I mean, I certainly think that Mr. Hampton, representing the plaintiffs, is you know, would be entitled to ask me to set it for trial. I certainly wouldn't do it if our potential trial dates were 60 days away or 90 days away or something like that, because with outstanding discovery, that would put everybody under too much pressure to be able to complete that. Since we're talking about probably 13 months, I don't see any reason that it would take that long to get the discovery wrapped up, other than just the fact that if you have that much time, you might keep thinking of questions you want to get answers to. But other than that, I think the basic things that you all would need to exchange in discovery should be able to get done sooner than that. So here's what I'll do. I think if he's going to ask me for a trial date, I will go ahead and set one. I will, Mr. Hampton, you're probably talking about March. What are you thinking? A couple days on this?
At most, it may be one. Well, you know, time you set the jury and all that stuff. So that takes half a day to get done.
The big unknown for us is what's going to go into selecting a jury, because like most places, we don't have enough room to bring a large panel of potential jurors and have them all staying 6 feet apart and select them all at one time. So we would probably have to do it in phases. And that's going to make any jury selection take 2 or 3 times as long as it would normally take. So that being the case, why don't we look at March 22nd and 23rd, which would, and if you wanted, I mean, I could go ahead and set it for 3 days if you wanted me to. But again, I'd like to think we'll be in a better situation then than we are now, space-wise.
That's okay with me, Judge, and we may have some motions we need to file after we finish this discovery, but we can always get those set for a regular
Yeah.
rule.
I was going to say, since the discovery, since I think you all are going to be able to get that accomplished without a ton of extra effort, why don't I give us set us a status conference sometime in let's say late summer or something like that, and then we can talk about motion. You won't necessarily have to file any motions by then, but we can talk about whether there are contemplated to be any motions, and if so, we'll get a schedule for that. Okay.
Okay.
That's
All
fine
right.
with us too, Your Honor.
All right. So let's go over maybe to, you want to call it August? Let's call it August the 16th.
Okay.
That'll work.
And we'll just do that on a docket, a regular rule day docket at 9 o'clock. That's a Monday morning. And, at that point, we'll have a status conference and we'll talk about our path forward. Okay.
That'd be great.
Okay, great.
All right.
Thank you, Your Honor.
Okay. Thank you.
Thanks, Judge.
Iglesia Bautista versus Piercy.
Brian Pack here on behalf of the plaintiff.
Hello, Brian Peck.
All right, Judge.
This is a motion for default judgment. Is Mr. Piercy on?
After I filed the complaint, he reached out to me and had made various promises that he was going to bring me documents to suggest the amount owed was not correct. I have never received those documents from him. I've not received any written answer from him. And after a year, I've quite frankly just kind of lost patience and filed the motion.
Understand. Did you make any representations to him, Mr. Peck, that you would not have this hearing?
I think initially when we talked, I told him I would not seek a default if he were to provide me some documents or something. If we were in communication, then I reached out to him again, did not get a response, reached out to him again and did not get a response. And most of this we're talking about, it happened in 2020. All of it actually happened in 2020, early 2020. I can tell you my last.
Oh, so nothing has happened since you filed this motion. Is that what you're saying?
Oh, nothing's happened since I filed the
All right, all
motion.
right. I thought you were indicating that after you filed the motion, he reached out to you, but you're saying after you filed the complaint to begin with.
Oh, yeah, we're talking about back in August of 2020.
So there hadn't been any communication, are you saying, since August, September of last year?
September 5th is the last time I talked to him of 2019, actually.
Oh, 2019. Okay.
Yeah.
All right. All right.
Yeah,
Well,
so,
it would appear that the complaint there has not been a responsive pleading filed pursuant to the civil rules, and therefore I think your client is entitled to a judgment by default. The amount is liquidated because it's set by contract. So I don't think that there is any evidence that that amount is not accurate as set out in the complaint. It wasn't an unliquidated damages claim, so I don't think a separate hearing needs to be held on the damages either. Okay.
all right.
So I believe you tendered a judgment. If you didn't, I'll do one, or you can tender one, however you want.
I tendered one.
All right. All right. We can get that entered. Okay.
All right. Thank you, Your
All
Honor.
right. Thank you. And I will point out for the record that when you filed your motion, I did enter a notice setting this Zoom hearing and providing the access information for the hearing if Mr. Piercy wanted to access it. So this isn't something that's just being done without him having the opportunity to reply. Okay.
All right. Thank you, Your Honor.
Thank you. 20 CI 398 Garner and Garner versus Thorpe and TJ Sampson Community Hospital. I believe we have a motion to intervene. Is that right? On behalf of the insurer?
That's correct, Your Honor. Austin Flaw on behalf of Anthem, and that's my motion to intervene. I've received an email from plaintiff's counsel that he has no objection at this time, and I believe at least one of the counselors for defense is here today.
Good morning, Your Honor. Morgan Motley on behalf of Dr. Thorpe. We have no objection.
Okay,
Good morning, Your Honor. David Thompson on behalf of TJ Sampson. I don't have an objection to the motion, Your Honor. I do have an objection to the tendered order. The order grants the motion, which I have no problem with, but the language says the motion intervene on behalf of Anthem, comma, proceeding in the name of plaintiff Jamie Garner shall be granted. And so I'm not aware of any authority for someone to intervene and then proceed in the name of someone else. I mean, if Anthem wants to intervene, I have no objection to that and we'll file an answer. But if Anthem is going to be involved in the case, then I think Anthem has to be a party to the case.
yeah, I don't know that I've ever seen that either, so I guess I'll hear from you as to why that would be appropriate if it is.
Your Honor, no, that's fine by me. We can alter it so that Anthem is a named party in the case.
Okay. You want to just, how about you do this? How about you just prepare another order and just email it to these other folks and let them, just so, because they got to see this one, just to be sure that everybody got to see. It doesn't have to be an agreed order or anything, but just, circulate it so that everybody gets a chance to take a gander at it. And then I will, if you want to upload that, I'll sign it when it gets into my electronic queue.
Yes, Your Honor, will do.
Thank you.
Thank you very much.
Thank you, Judge.
I didn't recognize Thompson. He shaved his beard.
Going incognito today.
His previous incarnation, the last few hearings had been, he was Snow Day David Thompson, and now he's back to.
I even put on a tie for you, Judge.
Even has a tie on. Okay.
Yeah. They were calling me the Unabomber after the last one, so I had to do something.
Well, I wouldn't have called you that, but
of course not. Of course.
All right.
All right. Thanks.
We'll see you all. Thank you.
Thank you.
20 CI 464, Campbell, Rarick, and Rarick versus STMCA et al. This is the motion of, let's see, I'm going to guess this is Mr. Richardson on here. I don't have a camera. It's just have a name, but this appears to be the motion of the plaintiffs to strike a responsive pleading that has previously been filed in the case. Are you on here, Mr. Richardson?
I am.
All right.
Can you hear me?
I can. Oh, you called in by telephone.
Well, we couldn't get the audio to work on the Zoom, so
okay.
I need some young fella like Larry Hinton to help me.
Yeah, Mr. Hinton's got it down pat. He's not had any problems at all getting on these Zoom calls. Mr. Richardson, since now that I know that the phone, I have just an icon that's a telephone. So now that I know that's you, I know you're on here. This is your motion to strike. What would you like to say in support of that motion?
Well, I would say to the court that STMCA is a limited liability company. Therefore, if it proceeds in this action, it must have a licensed attorney to file a proceeding. That's the law. An individual can proceed pro se, but a legal entity such as a limited liability company and a corporation cannot. This defendant has had 2 extensions of time, 2 ex parte extensions of time, and now filed an answer by an officer or a member of that company. The case law is clear that answer should be stricken. It is void, has no impact, and as a result, my client's entitled to a default judgment for the relief demanded.
All right. Ms. Hill, I see you on here. Ms. Hill is...
Good morning, Judge.
All right, hold on. Ms. Hill is the individual that filed the responsive pleading that Mr. Richardson has objected to. I need to make an observation. First, the observation is, my first observation is that Mr. Richardson is correct insofar as a limited liability company is not, for the purposes of practicing law, an individual or natural person that can represent itself. It is an entity that, like, you know, a corporate form that must be represented by a licensed and practicing attorney if it is represented at all. I do not know whether Ms. Hill is an attorney or not, but I wanted to make sure that we were stating that we were, you know, firming up on the record that I'm going to allow her to respond to what Mr. Richardson has said without treating her as an attorney unless she tells me and establishes to me that she's an attorney, because I don't want her to get in trouble for being on this hearing and be accused of practicing law. But it's possible that going forward, she might be accused of practicing law if Mr. Richardson is correct about his allegations. So, Ms. Hill.
May I interrupt one thing?
Yes, yes.
I, other than you asking her if she is a licensed attorney, I would object to her saying anything else in this case.
Well, I understand, and we're not going to talk about any of the facts of the case or any of the, I mean, we're basically only going to talk about what is contained in your motion to strike, because I think that's appropriate. But I do need to inquire of her what her status is as far as being an attorney, and if depending on what she tells me, I may have to ask her something else. So, Ms. Hill, the question obviously that I need an answer to first is, are you, when you filed these documents, did you file them as an attorney?
No, sir. I filed them as a pro se, and I was not aware that I couldn't because I'm the CEO of the company now.
Understand.
And also, I wanted to say up front, had I not called your office on Monday, and I've tried to file all these responses on time every time, and I'm not trying to play the role of an attorney. I have been in the process of getting an attorney, and I've been out of time, and I've had other issues because I'm a kidney transplant patient, and not making excuses at all, but the COVID has also played a part in it. I've also had trouble finding an attorney here in Bowling Green, considering the facts of who all this involves, because there's many lawyers in Bowling Green that is involved. And so I've had 4 or 5 to tell me that it was a conflict of interest. So that has put me at a disadvantage because there is so many involved in this situation.
Okay.
But
well, let's stick to the topic at hand, which is whether or not Mr. Richardson is correct that the pleading should be stricken on the basis of it being filed by somebody that's not licensed to practice law. And his observations and recitation of the law is correct. This is not something that happens all the time, but it is certainly something that has happened with enough frequency. You know, I've been doing this job at different levels for 14 or so years at this point, 13 or so years. And so, you know, it comes up an awful lot. And I'm familiar with the, without citing any case law, I'm certainly familiar with the case law that he referenced. And he is correct that an LLC cannot represent itself, just like, you know, Exxon Corporation can't represent itself, you know.
Right, Your Honor, I understand that.
Yeah, so he's correct, at least insofar as the responsive pleading can't be accepted. I mean, it's been filed and it's of record and nobody's going to take it and shred it or anything like that, but I cannot accept it as a pleading that meets any guidelines or for that matter, any deadlines, right? So another part of his motion is that since the pleading is not appropriate, then the deadline to file a responsive pleading has come and gone, and he is asking for his motion for summary judgment to be granted. That motion was filed, golly, November. I'm trying to recall back without looking through the file here and wasting everybody's time, but I believe it's been, you know, at least 3 months that this has been kind of lingering. And he's correct that I've at your request, and of course, this is part of why it's important to have people that are well versed in the law, is because you didn't really know how to ask for things, and you wrote a letter and sent it to me asking for more time, which I granted on 2 different occasions. Mr. Richardson is also correct that those were done, I guess, on an ex parte basis, for lack of a better way to put it. But I mean, I did orders and put them in the file because, you know, there wasn't any communication with you other than that request. And you know, certainly there hadn't been anything hidden in that regard. But I did not think that you were in a position to know how to file a motion and set up a Zoom hearing and all of that. So that's why it was done that way. But he is correct that, you know, there have been 2 different extensions. And at this point, neither one of those extensions has been complied with because this latest pleading is not going to be acceptable.
Your Honor, if I could ask, I have been talking to an attorney, so I am in the process of getting an attorney. And as I said before, I've checked with like 4 or 5 different ones. And so it's not lack of trying, it's just that there seems to be a conflict of interest with most of these here in Bowling Green. So I was not aware, and my apologies, and all due respect, I do want to honor the court, and I want to honor what you are saying and what Bobby is saying. I'm not exactly sure why Larry Hinton is in, but.
Well, he's here for a different case.
Okay. Okay, I thought Bobby.
He's just patiently waiting for his case, which is coming up next.
Okay, I thought Bobby said he had asked Larry to be in. I'm sorry, I misunderstood.
No.
But yes, with all due respect, I understand what you're saying. But at the same time, I would like to not have to spend that money on the lawyer and pay the $14,000 sum to Mark Campbell on 901 Mammoth Cave Road, Lot 8, and get that free and clear. And as I've spoken with Mark Campbell, even recently, we have discussed that. And
Honor, I'm going to have to object to all this.
Well, none of that. Yeah. I mean, all I would say about that is that I'm never going to keep 2 different parties on opposite sides of the versus in the case from trying to work out their differences. But whether or not they're trying to work out their differences generally does not get in the way of the court, you know, doing whatever it needs to do. You know, if somebody works out a difference and they let me know that they want everything resolved or partially resolved or whatever, and it's by agreement, I'll be happy to do it. But I mean, I can't stop what I'm doing. And I don't mean me personally, but just as a court, you can't stop what you're doing because people say, well, one side says, well, give me more time to talk about this, or, you know, give me time to make an offer to that party or whatever, because those are the kinds of things that need to get done before it gets up in front of the court to start making decisions.
Right.
Listen, here's where we're going to go from here. I am going to grant the motion to strike the response or the response. Mr. Richardson's other motion, the original motion, which has not ever been ruled upon, you know, I can't commit to ruling on that because I don't just grant these motions without reading them and going through them all. And I've not ever done that because I gave you time to file the response. I'll have to go back and look at his motion. And, you know, I'm not going to tell you whether it's going to be granted or not because I don't know whether it's appropriate to grant it. But I will tell you that I'm going to look at it. And if it's appropriate to grant it, then I think that his clients are entitled for it to be granted. But again, I'm not going to commit to it because those are decisions that you have to make on the basis of each individual pleading. You understand what I'm saying?
I understand.
Right. So he has asked for that, and I will take a look at that. But
I'm sorry, I couldn't. Hold on just a second. I'm sorry, I couldn't understand.
Yeah, I said that he has asked for me to do that, and so I will do that. But the item that was foremost on the agenda for today was whether the response would be stricken, and I am granting that motion. The response will be stricken because of the reasons that we talked about. You know,
Okay, if I may ask, where do we go from here? I mean, I'm in the process of getting an attorney to represent me. So,
well, if you're still doing that, I mean, if you're doing that, then you can proceed with talking to somebody and telling them what happened here today, which what happened here today is that, and this is attorney speak, so if you tell this to somebody, they'll know, I granted the motion to strike your response, and I took the motion for default judgment that Mr. Richardson filed in November under advisement, and I will review that motion. And if it's appropriate to grant it, I will grant it. If it's not, I will enter a different kind of order. Okay?
Okay.
All right. Mr. Richardson, anything further?
No, Your Honor.
All right. So that takes care of that case, and we can get to Mr. Hinton.
Thank you, Your Honor.
Thank you. Mr. Hinton, you're here for, is it Psycho Holdings versus Sikorsky? Wait, you're on mute. I can't hear you. I'm sorry. Sorry. Or are you here for the next case? I have 2 left. I guessed wrong. Let me call yours then, since you've been, oh, you're here for Service One versus Pool.
Correct. Can you
All right.
hear me?
I can now. Yes, sir.
All right. The reason I'm not as proficient as Mr. Richards would have you believe, a paralegal turned this on for me, and that's why I've been on.
He was buttering you up for some
That's
reason.
right.
Yeah.
John called in, said he had no defense. He couldn't wait and be on the hearing, and he said I was entitled to the summary.
Okay. Yeah. And by John, I guess you're referring to Mr. Rogers, who filed.
John Rogers, and he also told me there's a possibility of a bankruptcy filing.
That doesn't take a lot of imagination when we see him file.
Not
these.
with Mr. Rogers. No, sir.
He files these 2-line responses. You kind of know where they're going. Yeah.
Sure.
All right. All right. I'll grant it.
Thank you.
Thank you. All right. Mr. Basil, we're back. I'm sorry. Psycho Land Holdings versus Sikorsky and various others.
This is my motion for default summary and order of sale. We had no response from anyone other than Berrien County. To the best of my ability to ascertain, everybody's been served. It's a little harder for me to figure that out now that I can't go and lay my hands on the files, but I believe everybody has been served either in person or by warning order attorney, and no responsive pleadings have been filed, like I said, other than by Berrien County. So we're asking to get the show on the road and get this one sold by Master Commissioner.
All right. I do not think that there's anyone present that's going to object to that. So I will let me, yeah, sorry. I was getting distracted by going through the pleadings and getting them in a certain order. All right. So, yeah, Mr. Basil, I think your motion is well taken, and I will sign it.
We're asking that these 3 lots be sold as one piece of property. They're very small lots, and we think they're probably worth more stuck together than to be sold separately.
Are they contiguous?
Yes.
Yeah. All right. Well, not only that, but do they touch each other?
Well, yes, they do. They are both.
Nice. Are they adjacent?
All of the above.
All right, good. Well, then that's you've probably justified your request 3 different ways.
They're everything but stacked on top of each other, Your Honor.
Oh, okay. All right. Yeah, no, that's fair. I will get that entered. I think you electronically tendered the proposed judgment as well as the order referring to the Master Commissioner. So when I can get a minute, I'll get on there and get all those things done. Okay?
Thank you, Your Honor.
All right. Anything from Dana? No? Okay. All right. Thank you all. Hello, Miss Bryant.
Can you hear me?
I can hear you. Yeah.
Okay.
Yeah.
I'm not
You're a bit
used to
early.
this thing.
Everybody will be coming in here in about 10 minutes. Okay. So just hang tight. And I'll use the same, Zoom meeting. So I'm just going to turn my camera off and go do some other things, and I'll be back at 10. Okay.
Okay.
All right. Just hang tight.
Okay. Hi, Titan.